The CPI report, Child Protection in Iowa, brought to you by Vocal, Victims of Child Abuse Laws. You can see our program on Channel 15 on Mediacom TV, all around Des Moines and in Des Moines on Sunday afternoon at 1 o'clock, and again it's repeated at 9:30 on Wednesday evening. You can also see the program on Cox Channel 23 in Council Bluffs. The program out there is aired every other Thursday at 4:30 p.m. You can email us at vocaliowa@mchsi.com. My number here in Des Moines is 515-276-3956, and John's number is 515-282-2672. We take telephone calls from parents, and we try to help on a one-to-one basis, giving them our experience over 20 years. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report. We're pleased that we can enter your living room all through central Iowa and share some things that we think are essential with respect to child protection issues. That is one of our main missions, is to influence public policy as it relates to child protection issues. We believe that some of these issues are not being well addressed in the public sector, and that it's about time that we begin looking at that. We also work, as Don mentioned a moment ago, we work with families on a one-to-one basis. We're not attorneys, so we cannot hold ourselves out to give legal advice. However, we can give you some hints and some direction that may be helpful to you as you work with the Department of Human Services and the juvenile court. And quite often we find that the individuals we work with are not enormously wealthy people. In fact, quite the contrary. Some people have to go and depend on court-appointed attorneys if they're in the juvenile court, and some of them have to go without. If it's a divorce case or something like that, they either have to do it themselves or mortgage their future in order to get an attorney. So we're going to be hearing a little bit today about a project called Pro Se Project. And I don't know for sure the outcome of this, but we'll have some comments on that from a fellow by the name of Terrance Walker in just a few minutes. Here's Terrance. We just checked to see if he's in his office there.
Alive and well.
Okay, alive and well. Okay. There are some things that will be coming up in the State General Assembly, which convenes on January the 9th. So it's important that we begin thinking about the things that our legislators should be zeroing in on. One of those things is a move to undo what they've already done, and that is House File 619. House File 619, along with a bill that was generated back in 2002, causes all kinds of difficulties for individuals who are leaving prison, having been convicted of burglary or some crime, particularly a crime against a child, and causing these individuals to move out of their area and causing all kinds of fits. In fact, what it is a means by which the public can legally create a hate situation. But it seems as though these people are creating a hate situation, saying it's okay to hate, to commit a hate crime, if you're hating the right kind of person. So, what kind of a person can we afford to hate? Well, we can afford to hate a person who has just been released from prison, who is in prison for a burglary or an assault on a child or something of this sort. So we create a hate crime, permission to hate somebody, so much as to banish them from all community activities. In fact, the fellow who wrote the law, a fellow from Boone, who wrote the law originally, created the law because he heard a complaint that somebody was out of prison and was looking at children over the school fence. Well, that particular part of the law hasn't been written yet because apparently you can look over the school fence without it being a crime. But this is the mentality that is exercised. We also see, and Don's going to bring us a story here in just a moment, of a judge who decided that the children are a part of the state. The children belong to the state. Not a new concept because it dates back to the Greek city-states in which the children were officially made a part of the state. Don, tell us about a recent decision of the Ninth Circuit Court of Appeals on the left coast. Don?
Okay, John, I'm going to have you switch right over to the paper we got in front of the camera here. Thursday, November 3rd, this was written. School Sex Survey Ruling, Ninth Circuit. It gives the name of the first defendant. There were several defendants, several parents, these were, that filed an action in the district court, and eventually it went to the Court of Appeals against the Palmdale School District. In the U.S. Court of Appeals, it finally got up to for the Ninth Circuit, and the judge, Judge Stephen Reinhardt, on November 2nd, 2005, dismissed the lawsuit brought by the parents who were angered by a sex survey given to their students in a California school district. And here's a quote by this Judge Reinhardt, and he's been in there for many years. I think 20, I'm guessing over 20 years. I forgot the name of the president that was in office at the time that he came in. Anyway, as a result of that, we have a statement here by the judge, and I'll read it. We hold that there is no fundamental right of parents to be the exclusive provider of information regarding sexual matters to their children, either independent of the right to direct the upbringing and education of their children or encompassed by it. We also hold that parents have no process or privacy right to override the determinations of public schools as to the information on which their children will be exposed while enrolled as students. Finally, we hold that the defendant's actions were rationally related to a legitimate state purpose. So, based on that, you see how much power that the state has, and parents, according to him, have absolutely no power. Well, I disagree, and a lot of parents, a lot of people across this country totally disagree with the judge's thinking and the ruling that he put out. I'm going to read here an article written by Catherine Parker on this same issue. Parents take another hit in the cultural wars. And this was dated November 8th, a few days after the ruling. Parents, increasingly at war against a culture they find aggressively sexualized, just lost another battle, this time against the local school board. That's interesting. We vote the school board in, but once we vote them in, they can do whatever they want to. That's very interesting. According to the judge, that's his decision anyway. The article goes on. Rather, the state, in its far greater wisdom about right and wrong, has ultimate power over your kids. Think about that, parents. Do you want them to have ultimate power? This is not a new battle, of course. Parents and school boards have argued for years about sex education, but this decision is especially offensive because the children involved are so young. The ruling stems from a case filed by a group of Palmdale, California parents whose elementary school children were given a questionnaire of dubious content. In their complaint, now keep in mind that this kind of information is spread across the TV, so a lot of kids can pick up on it anyway. But does that give the school the right to pump it into the children's heads? Goes on. In their complaint, the parents say they would not have allowed their children to participate in the survey had they known of the sexual nature of some of the questions. And I just heard a little bit ago before we started this program that the school had sent out a little information prior to this happening to the parents, so the parents would have an idea of what's happening in the school. There were several things that was going to be presented to the school kids, but for some reason the school felt it was in their best interest, I guess, to withhold this part of the information. This is what angered the parents, having to do with the sexual information, that the school didn't even send the information out to the parents to let them know ahead of time what they were going to do. Now, the school told them about other things that were going on. I'm sure the Christmas play that's coming up and different things like that, but not about this certain questionnaire information that they were going to ask the children. Now, it goes on. Kids aged 7 through 10 were asked, for example, to rate the following activities according to how often they experienced the thought or emotion. Now we're talking about 6-year-old children, 8-year-old children. This is what they asked them to respond to in the questionnaire. Touching my private parts too much. Thinking about having sex. Thinking about touching other people's private parts. Thinking about sex when I don't want to. Is that being forced on them? Washing myself because I feel dirty on the inside. There are a lot of people that get the dirty feeling when they're involved in something like this, and the school is pumping that filth into their bodies. It goes on. Not trusting people because they might want sex. Getting scared or upset when I think about sex. Having sex feelings in my body. Can't stop thinking about sex. Getting upset when people talk about sex. Let me insert that the Bible talks about sex. God created sex. God created it and said it is good. But he put guidelines on it. He talks about that somewhat in the Bible. And if these people, this judge and others, can't comprehend what God has to say about the subject, I think they ought to get off the bench. Anyway, the article goes on to say, obviously, Not every 7-year-old is ready to contemplate these kinds of questions. Well, if they can't get married until 18, what do they need to know about it? Why is that more important to educate children on sex education than the, is it the 3 R's? It's been so many years since I've been in school, I'm not sure what they teach anymore. Reading, writing, and arithmetic.
In sex now.
Say that again, Terrance?
I said in sex now, obviously.
Okay. If you're a parent, there's no contest as to who should determine when such subjects are raised. Parents should. That's the bottom line. No, not so fast, and not according to the Ninth Circuit, according to what I read that the judge decided. The court made it clear that it was not passing judgment on the appropriateness of the questions themselves, but only on the constitutional issues raised in the case. Herewith, plaintiff's evidence as to why the law is, indeed, and why what is legal is not always right. Chief among the parents' arguments was that they were deprived of their fundamental right to control the upbringing of their children by introducing them to matters of and relating to sex in accordance with their personal and religious values and beliefs. Sounds reasonable to any attentive parent. Who else would decide when a parent learns about something so intimately bound to moral values? Apparently, the state should. Even though the Supreme Court has ruled that parents have a constitutional right to make decisions about the care, custody, and control of their children, the judges in this case ruled that parents do not have an exclusive right. Not to worry. Those hot flashes you're feeling are perfectly normal. Anger is an appropriate emotion under the circumstances, even if it's not constitutionally protected. In other words, the state can determine what's appropriate for your children based on what the state decides is good for society. Given that we're all concerned about sexual abuse and domestic violence, we should be permitted to ask children questions that might shed light on such problems, right? So goes the thinking. In other words, we leave it up to the children to make the decisions. Okay, let's see. Maybe there's a little bit more on the back side. Yes, there is. But as parents know, children are notoriously unreliable little scamps. And when it comes to answering questions honestly, especially questions they're not emotionally or intellectually equipped to understand. The most chilling piece of ruling was this assertion, quote, "We further hold that a psychological survey is a reasonable state action pursuant to legitimate education as well as health and welfare interests of the state." Really? So now the state is in the business of, let me see if I can pronounce the word, psychoanalysis. Psychoanalysis. Well, I'll leave it to the state to understand what that word means. Never mind that posing phase inappropriate questions to children might create psychological complications that didn't exist before the helpful questionnaire was administered. Yeah, now they open up the floodgates, is a good word, I guess, to more problems. While legal experts argue about whether the ruling is constitutionally correct, common sense tells us that the superior right of parents to instruct their children about sex is among the most fundamental of parenting concerns. The idea that the state knows best is not only ludicrous, but also dangerous. Bit by bit, with rulings like this, the state gains greater power over family autonomy, thank you, and inevitably over personal freedom. As the implicit message sinks in that the state knows best and parents aren't to be trusted, advocates for private schools and voucher programs should have no trouble finding new recruits. John, you were a day or so ago saw a TV program about this 15-year-old boy marrying an adult woman.
Yes.
Would you say that some of this sex education by the schools helps encourage such a thing?
He probably had a sex education overload on that thing. What's going to happen in this case, because there is a huge raft of case law that protects the parents, case law that goes back before the turn of the 19th, before we went into the 1900s. So it's a part of our American jurisprudence to give the primary authority to parents and not permit this elbowing in by judges or other folks. So I think you're going to see this Ninth Circuit Court decision taken to the U.S. Supreme Court for a final determination. And a lot of these cases that are coming out of the Ninth Circuit now are just almost laughable. I wouldn't call this particular one laughable. This one is regrettably sad that the judge decides what the compelling state interest, that is the principle upon which they were basing this case, that there was somehow a compelling state interest that was in place here, and that the school had a constitutional right to follow that compelling state interest. They didn't actually say what the compelling state interest is, except welfare.
What's the legitimate basis? I didn't understand what the legitimate basis was.
I don't think they articulated that, and I think they want to make sure that it is not well articulated. Because if you articulate what the compelling state interest is in the mind of the judge, it could certainly be under attack. The children do not need sex education until they get married. I think
Or sex surveys.
right.
At 10, was it 10 years old?
Six.
Six?
First grade.
Yeah.
Oh, wow.
See, you need this information, 2 weeks before you get married, but you don't need all of this nonsense, this sexual interaction with other people before you get married, because it would be illegal anyhow to even ponder it and to awaken the sexual interest of a child at a time when he should be learning his geography is downright dumb.
Well, we're talking about ABCs, though. At 6.
Yeah, right.
They're not even ready for geography,
No way.
much less sexology. So,
It seems as though we've gone way out of bounds with this concept, and they're doing the same thing in the Department of Human Services when they indicate to us that the department is the better parent. If the department is the better parent, you see, then that justifies removing many children from their real parents. And they're only asking for trouble. They're only asking for greater and greater expenditures of funds. So I think in this legislature coming up, we're going to have to ask our legislators to watch it with respect to any moves on the part of individuals to take over the rights and privileges of parents as they work with their own children. And I think this House File 619 needs to be completely stricken from the books. It was a plaything that the prosecutors wanted to happen. It is not anything that we need in Iowa at $5.3 million a year to operate, and up to $12 million to keep in place as time goes by. Well, you can see some of the problems that we have in the child abuse area as we go to court and as we attempt to get the kind of relief that we're seeking. That's why we have taken a real interest in what Terrance Walker has been telling us about how we should be looking at our judges. If we don't like the laws that are being foisted upon us, we need to tell our assemblymen to repeal those laws, such as House File 619. If it's a dumb law, get rid of it. If we don't like the kinds of decisions, and we recognize that they are decisions that are in opposition to the rights of parents and families, and that they're unconstitutional, there's another way of getting relief, and that is get rid of the judges that have that mindset, the mindset that says we can do anything we please. Why do we make certain decisions? Because we can. Well, Terrance Walker has looked into some of these cases and has some good thought with respect not only to the cases that we've been looking into, but to some of the studies, such as the pro se study, that leaves out pro se people in the study. One would think that if you're going to study a situation that involves pro se litigants, that you would involve pro se litigants in the study. But that is beneath their dignity. This can only be done by lawyers and judges and people in the upper echelons of our society, certainly not for pro se people. Here now, Terrance Walker.
Thanks for having me on the show again, John and I was going to get back to that issue of the pro se clinic that you had yesterday, or not that you had, but that you went to over at the Drake. Was it the Drake Legal Clinic?
Right.
Is that where it was at? I do think that was kind of insane. Sort of like if you have a forum on what to do next time there's a hurricane, and you don't go to anybody that was a victim of the hurricane. What kind of sense does it make to have a pro se legal, a legal clinic on pro se people that represent themselves or go to court without attorneys, and you don't have anybody there that's invited that is actually represented themselves? And I think this kind of underscores the people rationale or their mindset in the judiciary and the legal profession. A lot of them tend to think that they know it all.
Makes them one-sided in their viewpoint then.
Yeah, and here's we're supposed to have a bunch of people who are supposed to be symbolically represented by a woman with a blindfold on it and a scale. Well, I don't think these guys have a scale, but I guarantee you they have a blindfold on, because there's no way that you can understand how a pro se person feels or what kind of need they have if you're not going to the pro se people. It kind of reminds me of again, I'm going to go back to the Hurricane Katrina analogy. What if the reporters, instead of going down asking the people, well, what's going on with you over here in New Orleans or in the Gulf of Mississippi, what happened, how did all this water get here, and what happened to your house? What if they talked among themselves and came up with their own ideas what happened? We might not even have known what happened with the whole Katrina thing if the journalists took the same approach as the judges did. So, I mean, it tends to, when you put it in this light, it tends to make the judiciary look really bad, I know. But I think they make themselves look bad. It's not obviously something that is well thought out when you have some situation. But I'm going to get back to that. I had a story I usually talk about the judiciary here in Iowa, because we do have some say-so over that here in Iowa. We have the power to vote out the judges. Every retention vote, whether it be 2, 4, 6, or 8 years, depending on the rank of the judge. We do have the authority and the power to go into the polls and vote them out of office. Hasn't been done, But we do have that power. And so I've headed an organization called Vote Iowa Judges Out, VJO, for the past couple years. Um, and, you know, we've been trying to get the word out that people need to do that here in Iowa. That way we can take back the judiciary from people that don't have any sense. When in the judiciary, there's a lot of people, obviously, that don't have sense. But we've got a case on Florida judges. Really nice article I've seen on law.com. If you're ever on law.com on the internet, check that out. There's a lot of interesting information on law.com. 11/15/2005, Julie Kay of the Daily Business Review reports, last month, a three-judge panel of the 11th U.S. Circuit Court of Appeals chastised the Southern District of Florida for completely hiding cases from public view by placing the cases on a secret court docket. Now, this article is entitled, Florida Federal Judges Slam for Secret Docketing.
What's a secret docket? Can there be anything secret in the court?
Well, as John has just shared with us, the judges have obviously taken up the opinion, unwritten opinion, that they can do anything they want. And this obviously is a case of that, a couple cases of that. Obviously, these federal courts in Florida, the district courts anyway, have been secretly hiding case files. So you go to the court to find your case file, and it's not there. There's no number, no case number, there's no file. Even if you're a defendant in the case, you can't find the file. They're not going to give you any copies of anything. Well, defense attorneys, civil liberties groups, and the news media celebrated the panel's words, which came in the course of upholding a drug lord's conviction and sentence of more than 30 years in prison. And this is what the court said. We exercise our supervisory authority to remind the district court that it cannot employ the secret docketing procedures that we explicitly found unconstitutional. And this is what the 11th Circuit said a couple days ago. Now, one of South Florida federal judges who agreed to hide a case admits that she made a mistake and vows never to do it again. Judges are not God, she says. U.S. District Judge Patricia Seitz, a 7-year veteran of the federal bench, said in an interview, like any human being, we make mistakes. When your mistake is pointed out, you reconsider your action and you promptly make a correction. Well, I wish more judges thought like her. But while Seitz, who sits in Miami, said she would be surprised if any more cases now are being superseded in the Southern District of Florida, other observers say it may still be happening. How would you know? Asked Randall Marshall, legal director of the ACLU in Florida, which filed an amicus brief in the 11th Circuit case. There could be others, definitely. There is also another reason for concern about whether federal courts have come clean on the secret dockets issue. In its 84-page ruling in USA versus Juan Nichols Berganzoli and Fabio Ochoa Vasquez, released October 20th, the 11th Circuit panel failed to acknowledge that the appellate court itself was deeply implicated in secret docketing. The opinion was written by U.S. District Judge A. Vance Edenfield, a visiting federal judge from Savannah, Georgia. Frank Hull, the judge, also concurred. Judge Rosemary Barkett, who is based at the court's Miami bench, wrote a lengthy separate opinion in which he partly concurred and partly dissented. 2 years ago, the 11th Circuit kept secret a docket and opinion in the habeas corpus case of a young Algerian waiter living in Deerfield Beach, Florida, Mohammed Kamel Balahawa, who was detained in a terrorism-related investigation. And they go on to also discuss a case and where there was also on the next page, where they also discussed a case where the individual had a secret docket, and this was in a drug case. So, as we see, they've opened up Pandora's box on this whole thing. It started with the terrorism stuff, but it's going to end up resulting in terrorization of citizens, as we see. The First Amendment is supposed to protect us from these abuses, not only from the criminal rights, access to the criminal records by the defendants, but also for the public and the press. So, that's the danger when these judges start thinking that they are above the law and they can do what they want. We start to see a situation whereby, not only are they justifying it in one case, but they're justifying it in all the cases. So who knows? You may be implicated. You may have a case which is secretly had on you. Matter of fact, in one of the other cases, they had a case where it was a secret juror. So how do you know whether you've been judged guilty by a panel of your peers when you don't even know if there are a panel of peers there? Again, like I said, they're opening up Pandora's box on this whole thing. And I think that's another reason why we need to get on these courts to not only open up their records and be open about what they're doing, but also to be honest and play ball with us as citizens, because it's our courts, it's not their courts, but they tend to, unlike what the judge Patricia Seitz said, don't think they're gods. A lot of them do think they're gods, and they have a godlike complex. Did you have a comment on it, Don?
Oh, yes. I want to just say that this is not only happening in the federal court, that this happens in your local county courts, too.
Yeah.
I had an experience, what year would that have been? October 1985. I had no knowledge about it at the time, but then, let's see, I'm not sure. It might have been a year later that I was in contact with the local sheriff, who I respected, and in fact, he made a special phone call up to Des Moines when I'd moved to Des Moines, and he told me that he had a file of information on me that I could get copies of. So I go back down and get a copy of the information, and in that was a criminal action against Don Burgmaier. Well, who is the last person that's supposed to know about being a defendant on a criminal action? Well, anyway, I did some research on it, and it was 2 or 3 years after that, maybe, that I filed an action down there, and I went to the clerk of court and during that period of time and requested to see that file. I had the case number, everything where it had started from, and she did some searching, and she said, I don't have anything on it. I put her on the witness stand to testify under oath, and she still said the same thing. That I had to prove that there was a case, and yet they had none. And I came to the conclusion that it was the county attorney at that time that had pulled that file out of there. He started the action. He got what he wanted. He got a search warrant. That he got some action on it, but it didn't, in the end, didn't go anywhere. So he pulled the file. That's my belief. I have no proof on that, except for in that same court hearing, I got him on the witness stand 2 different Mondays. It lasted over a week. We had hearings on Monday, and then it was continued to the next Monday because it's a rural county. And I got him to testify in front of the judge, who I thought I could trust. And he said he shredded all the records, and they're at the bottom of the landfill. Judge didn't care. Clerk of court didn't care. And I didn't know how to proceed from there, just because there's a county attorney that's filing actions and then shredding them just for his whim, his benefit. Terrance?
Wow. That's just shocking, I tell you. But it's not surprising, considering the level of devious actions that are going on within the judiciary right now. One individual, Representative Steve Chabot in Cincinnati, has obviously had enough with the court secretness, and I think the article is back behind the other one. And he proposes, Steve Shabbat of Cincinnati, proposes to allow cameras in federal courts. Something I'm sure that our friend John Harvey would definitely enjoy, since he's been a avid court photographer. This comes from us from the Cincinnati.com website, The Inquirer, dated November 15th of this year. U.S. Representative Steve Shabbat of Cincinnati has something in common with Sisyphus, the eternally frustrated rock pusher of Greek mythology. For the past 8 years, Shabbat has been pushing a cameras in federal courtroom bill up the Capitol Hill, only to see it roll back down again and again as the Senate ignored it. This time could be different. Last week, the House passed Shabbat's Sunshine in the Courtroom provisions 375 to 45 as part of a court access security bill, and Senate Judiciary Committee or an inspector has expressed support for the idea. Shabbat's measure would give all federal judges the discretion to allow TV cameras into civil and criminal trials as well as appeals on a case-by-case basis. Currently, only appellate courts have such authority. We hope the Senate follows through and approves the idea. During a time when America's civic literacy seems to be on a steep decline, easy public access to court proceedings can advance the cause of an informed public and strengthen Americans' ability to see that their justice system is working fairly. Well, that's a million-dollar phrase. This is good public policy if you are a believer in open and accountable government, Shabbat said. Exactly. Congress and many state legislators routinely air their sessions. Every state now allows courtroom cameras under some circumstances. Many cities and counties put boards, councils, and courts on cable access. As the use of cameras has grown, traditional rationales for opposing the broadcast of trials have melted away. Detractors used the infamous O.J. Simpson criminal trial in 1995 to argue that TV cameras could turn a trial into a media circus and corrupt the process of justice. Not long after the O.J. verdict, Justice David Souter told the House that if a TV camera were to enter the Supreme Court, it would have to roll over my dead body. But as we've learned since then, the Simpson trial was a spectacular aberration. Even that media circus taught the public much about criminal law and constitutional rights. And the many criminal proceedings on outlets such as Court TV, while some may have their voyeuristic aspects, on balance have aided the cause of legal literacy. If anything, cameras may be even more important on the federal level, where judges receive lifetime appointments and are removed from public scrutiny. Not that cameras would make celebrities out of these judges. Most federal trials are far less likely to be ratings blockbusters than Insomniac's sure cures. Any abusers could be avoided through well-crafted rules and judges' careful discretion. As the vote on Shabbat's measure indicates, it's not a partisan issue. In 1997, he co-sponsored the cameras bill with then Representative Chuck Schumer. Resistance has mainly come from federal judges hostile to the idea of even having the option. You have to wonder what they really fear. That's a good point. At all levels and branches of our system of representative democracy, government works best when it works in the light. The Senate should let the sun shine into federal courtrooms. And I wholeheartedly agree. Did you have a comment, Don or John?
Our senior citizen senior senator from Iowa goes along with that.
Chuck Grassley?
Yes.
Okay, well that's good.
So, Terrance, this whole idea of the open courtroom was one of the central core ideas in the minds of the founders of this nation. And to see that whole idea being scrapped, I think is a crying shame. To have secrecy at any level of the court proceedings cries out for some change, and I think our state assembly should take a look at that. The General Assembly should take a look at that.
Well, could you imagine going to a football game, Iowa versus Iowa State, and they had a contested ruling on
Oh.
the field. And nowadays they review some of the plays if they come within certain guidelines, I guess. And instead of showing the contested play on TV, the referees basically said, well, we're going to we're going to privately review this, and we'll get back with you. And they make their decision. Everybody's wondering, well, how the heck did the call make? People would be in uproar about that if they had such a procedure. Well, here we have our life, liberty, and property being not only disputes being determined by these courts, which is more, I think, essential of a concern for us, as people that have life, liberty, and property. Most of us, anyway. We have it decided by these judges, and they want to secretly decide this stuff from public view. We should all be in an uproar. There's no way that we should be silently suffering the abuses that are going on behind closed doors and unbeknownst to a lot of us. That kind of stuff should be brought out to light. And I think what a lot of these judges fear is that they may have to play fairly and play by the rules and not only be open to scrutiny, but be open to just scrutiny. Sometimes scrutiny is good. It could be wrong sometimes, but most of the times scrutiny is good. So I think that they need to buckle up since they're making all this money, 6 figures most of these guys a year, and take some heat. If you are indeed righteous, you shouldn't be afraid of having some heat, especially since you're making so much money. I wouldn't mind the heat one bit if I was making what some of these judges are making, 120,000.
You change your mind if you got in office.
Well, 140,000. Maybe I'll do like the one judge and file for disability and still get 60% of my income for the rest of my life if I had too much heat. And I could file for heat disability.
Heat disability.
Well, one of the other things, I know that sounds kind of ludicrous, but it's kind of ludicrous what some of the judges did. A judge from Hamilton County had a drug charge, not drug charge, but a drunken driving charge, 2 of them. And on the second one, he filed for disability and got
stepped down from the bench.
Stepped down from the bench. And still retired with 60% of his income.
Maybe I should have said he staggered down from the bench. Yeah,
there we go. He staggered. He did. With a blindfold on, with his scales tipped. But anyway. Anyway, this is what we have here. We're just talking about the Pro Se conference that was just held without any Pro Se members, except for John Harvey. He just happened to walk in on the whole mess. I think he probably upset the whole establishment when he walked in there because he represented himself quite well. But anyway, Drake Legal Clinic on the, was it the 15th? I'm losing track of my days here. The 15th this month here in Des Moines, Iowa. They had the Pro Se Clinic without any members of the Pro Se establishment there. And as you folks can see here, there was a huge stack of papers that were brought out. I was gonna show some of that information for these folks. Look how thick this is. Holy smokes! Not a one of these documents here. There's about 5 of them in this big stack of documents. Looks like it was prepared by anybody that is a pro se litigant. And how are you going to understand something when you're not reading from the source? But anyway, report on the joint Iowa Judges and Iowa State Bar Association Task Force on Pro Se Litigation, dated May 18th, 2005 of this year. And they state, and I'll just paraphrase here, the challenges posed by the increasing number of citizens who oppose or choose to represent themselves in court proceedings have resulted in a number of states taking steps similar to Iowa to attempt to define the issues and design solutions that will increase citizen access to the courts. and legal services while minimizing disruption to an already overburdened court system. And they go on to say, other judges and court personnel report information such as the high case workloads or the high number percentages of people that are pro se that actually come to the court. And they go on to show how they got all this information from various sources. The task force reviewed the efforts of the Idaho and Minnesota people, or the courts, I guess, to establish guidelines for judges hosting pro se litigants in their courtroom. Members of the task force have also reviewed numerous articles on various aspects of the pro se issues and consulted with the staff of the American Judicature, I can't say that word ever, American Judicature Society, and William Hornsby, a leading writer in the area and a member of the ABA, Standing Committee on the Delivery of Legal Services. The majority of the task force also attended the Bench Bar Conference in Okoboji. Wow, that must have been a good fun getaway. The task force members found the presentation by the manager of the Hennepin County, Minnesota Self-Help Center, court-based, extremely helpful. Now, all these organizations and other government centers and things of that nature don't say, I mean, that doesn't mean that they consulted with any true authorities. If you're going to go to some authority on something in the legal field, they typically cite an authority when they rely on an opinion. Well, I don't see, as a pro se litigant myself, none of these authorities, so-called authorities, I would say are invalid. If you're going to consult myself, Terrance Walker, the judge of the judges, or this man over here, John Harvey, or Don Burgmaier, then you're going to consult an authority. Other than that, you're basing an opinion on something that's not an authority. Therefore, this opinion, I feel, is null and void. But anyway, what did you say, Don?
I was over at that meeting, the last half of it on the pro ses, and I asked a question after it was all over, and I told them I was pro se, and they encouraged me to go talk to an attorney. Well, the idea is to work with pro ses if they want to file in court, but no, I guess they're trying to discourage pro se people. Well, on one hand, I guess I can understand that if you get a lot of pro ses out there that are ignorant and just throw something at the court, it can get kind of confusing. So they want a standard, forms and things like that. I can understand that. But
they're looking at making their jobs easier. It doesn't seem like they're looking at making it a lot easier for the pro se litigants.
I've been filing for close to 20 years, and don't you think I have a little experience compared to going to an attorney that's only filed for 1 year?
Yeah, well, this is the case where they have the authorities, the so-called authorities, backwards. Most cases, they cite authorities. Now, I find it highly funny or highly suspect in this case. I shouldn't say funny, it's sad, but highly suspect they don't have any authority. Where's the expert pro se litigant that they cite in this study? I would have told them about some of the things they do. Some of the stuff that they do as judges to pro se litigants is not even discussed. Like, for instance, if you know your case, you research it well, you present your issue, and you do a good job, and they don't like you, they will ignore your issue because they feel that you're a pro se litigant and you don't deserve to be heard, and you most assuredly don't deserve to win a case against one of our own attorneys. That's the overriding opinion or the overriding attitude that I've received and the unwelcome reception that I've received in the American justice system, and especially here in the state of Iowa. And, you know, this goes on and on and on. I'm sure John Harvey, you had it, I guess they at least noted your presence there at the
Right.
clinic the other day. Can you tell me about that or tell folks about that?
It was just a casual mention that by one of the judges that I had, who is also on the panel, because of his relationship to my case, mentioned it. And I think it was in terms of playing an advocate role, because this judge did step aside from the normal judicial view of their role, and was somewhat helpful. I wish I had taken the whole case to the Supreme Court, though, to get a final ruling on the case. He did actually back out the criminal charge, but only after a jury hearing was on it. And he didn't do anything to wrap the knuckles of the individuals who were responsible for bringing this whole thing about.
Yeah. You're talking about that one case that you actually won. You got a conviction overturned.
Right.
Pro se. And Judge Robert Blake actually overturned. Now, this is a guy that's speaking at the thing. Wouldn't you say that he, here's a pro se guy that's obviously an expert, because I've noted he had a really compelling argument, and I actually overturned the conviction based on his argument. Don't you think he would have said, well, John Harvey, why don't you come speak at the pro se legal clinic, because we need your input?
Right.
No, he didn't do that. But I do have to commend him, because unlike a lot of the judges, I would say 99% of them, he did actually recognize your argument as a valid argument, and actually seen that you did cite some authorities, even though they're not citing no authorities, and overturned the criminal matter that they were initially pursued against you. But I would have to say that, no pun intended, but Judge Robert Blink, he gave a, any other judge wouldn't have blinked twice,
right,
to deny you your legitimate right to be heard. They would have just ignored whatever issue you brought up and just basically rubber stamped the conviction or the argument of the opposing party if you was a pro se litigant represent yourself. They would have just said, we don't recognize your argument as valid because you're not an attorney, and we're going to recognize this attorney's argument, and we don't care what you say. But I think having a show and being in the limelight does have some bearing on that.
I believe that happens a lot of times,
Yeah.
Terrance, for pro se people,
That's
because you carry the term pro se with you.
You bet.
Yeah, it's like a stigmatism.
Right, right. Well, I was glad to. I was glad that he did what he did in this case. He recognized that you can challenge the jurisdiction at any time, and he actually read my arguments. They were voluminous, but he read the arguments and made mention of those arguments. There are some telephone numbers that may be of interest to you if you'd like to be a pro se litigant, if you'd like to attack on your case. By the way, you know more about your case than any attorney will ever know. Exactly. And you have more of a desire to get the relief that you're seeking. We'll see you next week. Thank you for stopping by the CPI.